Yes, Mr. Horton.
My Lords, overnight, I apologise, a further set of extracts from various enactments and Law Commission reports have been produced. And I can just very briefly introduce that before restarting my submissions. My Lord, this extract is paginated in the bottom right-hand corner. It has 5 things in it. It has additional extracts from Law Com 25. We have in the Main Authorities bundle the summary of recommendations that relate to that. And what you have in that now is the extracts dealing with non-ancillary provision, as it's called, what became Section 27, and also the principle that payees remarriage brings to an end maintenance orders, as well as part of the draft bill from that Law Commission report. Secondly, we have the wording of the Matrimonial Proceedings and Property Act 1970 as enacted. That was the bill that effectively was more or less in the same terms as drafted by the Law Commission in their report. Thirdly, we've got the Matrimonial Causes Act as amended in Section 27 there. Fourthly, we've got the draft bill, or experts on the draft bill, from Law Com 77. That's the Law Commission report that gave rise to the...
Sorry, these are all in the same clip,
They're all in the same clip, my Lord,
right.
yes. And because they're paginated, I can, in due course, I'll take the court to the relevant pages of. I'm just saying, this is overview of what's in them. And then finally, we've got some extracts from the Domestic Proceedings and Magistrates Courts Act 1978, which was the act that followed on from that Law Com 77 report. And so, my Lords, I'll refer to them as and when needed. So, my Lords, yesterday I indicated there were 4 main areas I was going to address the court on in relation to Section 27 and the date at which the ground must be established. And I focused yesterday afternoon on the statutory language as the first of those. The second, my Lords, is the statutory context and history. As set out in the judgment and in my learned friend's skeleton, the High Court had no failure to maintain power until the 1949 Act, and it was the Magistrates' jurisdiction that had this power to start with. My Lords, yesterday's loose extract from Law Com 77 shows how that Magistrates' Court provision existed prior to the Law Commission report in 1977 or 76. That extract, from yesterday, has the front page of the report as its cover, and then part of the index, and then there's internal page 5.
Sorry, where are we?
My Lord, it's a document that was handed up yesterday that's part of Law Com 77.
Right.
I apologise for these supplemental authorities being pointed about.
So which page?
My Lord, it's internal page 5.
Right.
And that sets out what was then the current position for the Magistrates' Court's provisions under the 1960 Act. And you can see a long list on the following page, page 6, of the grounds that had to be, or one or more of which had to be established before a Magistrates' Court could make a maintenance order under the 1960 Act. And the point I make here is that with one exception, they are all past tense. They are all has deserted, has been guilty of cruelty, and so on. And I say that's part of the context, that in both the High Court and the Magistrates' Court, the focus of getting the ground established was past tense at the date of the application. My Lords will see the historical oddity that is letter F in that list, which is the ground being that the respondent is for the time being an habitual drunkard or drug addict. And I say that's the exception that proves the rule. Where Parliament wanted to use a different tense, it has done so. And my Lord, Well, as I say, it's also part of the canon, as it were, of matrimonial law, that, for instance, if one's bringing a behaviour petition, one can only allege particulars that predate the petition. And if one then wants to rely upon allegations of behaviour which post-date the petition, one has to file a supplemental petition. So I say it's a facet that pervades matrimonial law, that where the court is given the opportunity to make an order on proof of a ground, the ground must exist as at the date of the application. And my lord, that's not just a historical fact, it's a fact that under the current version of the Magistrates' Courts legislation, they continue to use the past tense. One can see that, my lord, in the same clip of documents. The very last page of that has, at paragraph 2.13 of the Law Commission report, the recommendations, and 2.13a and b again talk about has failed or has behaved, and one sees that in the wording of the 1978 Act as well, that it's the focus is on the past tense. And although the recommendation says is in desertion, actually the statute says has deserted the applicant. My lords, the Law Commission in that extract debated whether it was necessary to include any fault-based or grounds which corresponded to the old fault or matrimonial offences at all. My lord, if I can ask you to look at internal page 8 of that extract. They grapple with the arguments as saying, why not simply have failure to maintain? Why include desertion at all? And you'll see a sentence that begins 5 lines in the middle of that paragraph, which says this: we do not think that a deserted wife for whom her husband is providing reasonable maintenance should be required to wait until that maintenance has ceased before making her application. And my lord, I say that the clear premise behind that reasoning is that if desertion was not a ground, and in the Magistrates' Court one was only having a failure to maintain ground, if the failure to maintain did not exist at the time of the application would fail. And so, my lords, I say that that's important because this is the modern law of failure to maintain. It can't be dismissed as a case from another era where they all did things differently there. And so I say the express assumption behind these recommendations, and these are recommendations are part of the package that led to the modern Section 27 and the modern Magistrates' Court legislation, assumes that there must be a failure to maintain as at the date of the application. My lords, the next part of this bank of submissions just traces the language of what is now Section 27 throughout its history. Because it's my submission that insofar as the temporal aspect of the ground is concerned, there is no material difference between the statute as it existed at the date of West and now. My lords, if I can ask you to turn in the authorities bundle to the case of Morton, tab 8, I'm grateful, thank you very much. And it's page 273. of the authorities bundle, one can see in a footnote there the wording of the 1950 Act, which the court was dealing with. And one can see in footnote 2, it reads, where a husband has been guilty of wilful neglect, provide reasonable maintenance, then if it has jurisdiction to entertain proceedings for judicial separation, then on the application of the wife, the court can make an order.
Yes, I mean, you're coming in due course in your submissions to the fact that the provision is now in the Matrimonial Causes Act, which has a very different structure to the Matrimonial Causes Act 1950. So you're putting the provision in its statute, in its context, in the statute.
My Lord, yes.
So it might be the same wording, but it's in a very different statute.
Well, my Lord, I will seek to address that point in due course. Whether it's in a different statute or not, this submission is simply dealing with the wording of the provision.
Yes, well, the wording is different. Section 27 is much longer than this, and, for example, requires the court to take into account all the circumstances.
My Lord, and I'll come to that Section 27.3 point.
So it's not the same section, it's not the same provision. It has some wording that's the same, but it has some additional wording.
My Lord,
so
yes.
You'll need to address that.
And my Lord, for this purpose, the narrow focus of this purpose is on the first subsection of the relevant section, the ground, which is what I'm talking about at the moment, my Lord.
I see that.
So, my Lords, that's the Act as it was at the time of West in the 1950 Act. In my learned friend's skeleton argument at page 39 in the core bundle, my learned friends have set out the wording of both the 1965 Act.
Sorry, where are we?
Page 39 of the core bundle, my Lord.
Thank you.
That's paragraph 60 of my learned friend's skeleton.
Yes.
And the wording is very, very similar in the 1965 Act and the 1960 Act, which followed Law Commission 25. There is a change in the word order. So instead of saying where a husband has been guilty, you have the application first and then the grounds afterwards. But it's my submission there's no material difference in the temporal aspect between the 1965 and the 1970 Act. And that can be seen because there's no suggestion in Law Com 25 that the Law Commission was looking to change that aspect of the law. They had a number of criticisms to make of the 65 Act, but this was not one of them. And my Lord, I accept, and with that phrasing, albeit removing the words willful and making full gender equality, is how the 1970 Act becomes the current version of the 1973 Act.
Yes, now on that point, we've been told, and I don't understand if you're in disputes, that there was an amendment in 1978.
My Lords, yes.
But I've been struggling to ascertain the nature of that amendment because the relevant version of the Act is not on Westlaw.
My Lord, if I may, I'll come to that in a moment because I'm going to deal with the Section 27.3 point. And it's my submission, and I'm just foreshadowing that. Section 27.3 comes in as a result of amendments made in 1978. It's part of a package. The amendments made in 1978 are threefold in substance. They provide full gender equality for the first time in the High Court. They remove any kind of mens rea, so it's just a fact whether there's been failure to maintain. And so the old case is that the husband who was ignorant of his wife's circumstances couldn't defend an application under Section 20, what's now Section 27, and the West and West point would go as well. And thirdly, one has the introduction of the statutory checklist and the removal of the rule about adultery and therefore the end of matrimonial offences being a bar to an application to failing to maintain. For this purpose, my lords, and I'll come back to all those points in due course, for this purpose, I say that the use of the past tense is consistent throughout all of those bits of legislation, and the change in word order that happens in 1970, there's no material difference as a result of that. So, my lords, that's the statutory context. My lords, the third area of these submissions is authority. And there are two, I say there are two, but the main, obviously, authority I rely upon is West and West, which is 1954 probate reports, page 444, but I also rely on Morton as well. My lords, Morton and Morton is at tab 8, I'm very grateful, in the authorities bundle. It was a case where a husband had entered into a maintenance agreement in the 1930s and paid, it seems, on the nose every month. His wife made an application alleging that that was effectively no longer enough. And the question was whether or not the fact of that agreement stopped him being in willful neglect. Now, the point about when the ground must be established was not argued in Morton itself, but if one looks at page 282 of the bundle or page 747 of the report, one can see that there is, forgive me, I'm so sorry, it's the following page, it's, no it's not, I'm so sorry, it's page 743 of the report, forgive me, and page 278 of the bundle. There's reference there to a case called Tulip and Tulip, and that reference continues into the following page. On the last two lines of page 744, in the reference from Tulip and Tulip, you can see this passage. But the real question for his determination was not that, but whether, at the time the application was made to him, the husband had willfully neglected to provide reasonable maintenance. That must be reasonable at the time of the application. So,
sorry.
So where are you reading from?
Yes,
my lords, at the last but one line on page 744 of the report, the sentence halfway across begins, but the real question. And you can see there the ground, and into the following page, the ground must be made out at the date of the application and reasonableness is assessed at the date of the time of the application. I say that's in passing because I haven't cited Tulip and we've already got enough cases, and especially in the light of West, which I propose to turn to now. My lord, my learned friend referred to it briefly. It's the case of West and West, the same 1954 probate reports at page 444. One might say it was a strong constitution, Lord Evershed, Master of the Rolls, and Lord Justices Denning and Hodson. And one can see from the headnote of that report that the wife in that case brought a Section 23 application on the 16th of March 1953. 2 days later, her husband positioned a petition for divorce on the ground of her adultery. The trial judge in February 1954, dismissed the husband's petition and rejected the allegation of adultery. The following working day, on the 15th of February, the Section 23, what is now Section 27 summons came before that judge. And that judge found effectively that until the petition for divorce had been dismissed, the husband had grounds for suspecting adultery, and because he had to be guilty of willful neglect, he had, a defence to that. Notwithstanding that, the trial judge, the commissioner, found the husband to be in willful neglect and ordered a sum of £4 a week pending detailed investigation by the registrar. And the Court of Appeal allowed the appeal against that order, discharged that order, and dismissed the Section 27 application. And one can see from the judgment of Lord Evershed at page 448, and in particular, the third paragraph, beginning halfway down the page, that being the law, Lord Evershed says, "It seems to me the husband was entitled to maintain, when the 27 application was determined, that he had an answer to that application issued in March 53, and that he was therefore entitled to have the summons dismissed. But from the date on which the divorce petition had been dismissed, he was no longer able to refuse to maintain his wife, at any rate in the absence of some fresh ground of justification." It goes on to say that unless he now pays, or has paid from the date of the divorce petition being dismissed, the sum of £4 a week, he will be liable to have a fresh summons issued against him, to which he'd have no answer. But that is not what we have to decide. So the fact, the ground not being established at the date of the application was the basis upon which this court overturned the first instance decision, set aside the order, and dismissed the application for failure to maintain. And I say that, therefore, is the ratio of that case, that the ground must exist at the date of the application. And subject to anything that might be said about the impact of Section 27.3, the wording of Section 27.1 is in the same terms, and I say that, therefore, West and West is binding authority on this court. My Lords, before I come to Section 27.3, I want to make the fourth area of my submissions on this point, which is the overall construction arguments. The first of which is this, that it is, I say, basic common sense that you must have a cause of action as at the date of issue, and that you cannot simply issue hoping for something to turn up. My Lords, secondly, at all times, the plea from the applicant in a Section 27 case has been that the respondent has failed to provide reasonable maintenance. And my Lord Justice Arnold yesterday took my friend to the application form in this case. And for your Lordship's reference, that's at page 129 of the core bundle. We don't need to look at it again. But of course, that's entirely consistent with the historic position as well. And one can see that from Morton and Morton, if one goes back to that very quickly, tab 8 of the authorities bundle. Excuse me. One can see at the top of page 741 of the report, which is page 276, 276 of the authorities bundle, you can see right at the top there the description and the quote from the originating summons in that case. And you can see there the plea was that her husband has, at that time, willfully neglected to provide maintenance. My lords, yesterday, lunchtime, learned friend, Mr. Lang, provided for the court the modern updated form D50C, which is the form by which one begins a application under section 27 now. The relevant parts of that form have been highlighted, but again, just as with the current form, or the form that was in use in these proceedings, I should say, the allegation on the front of the form is that the applicant says respondent has failed to either provide reasonable maintenance for the applicant or make a proper contribution towards the children's maintenance. The form is longer and one can see more details that need to be included, but on the last page one can see now the family procedure rules catching up with the idea that originating process should have statement of truth. The applicant issuing a section 27 claim today will have to make that assertion and have it verified by a statement of truth. My lords, we've made a number of points in our skeleton, and this is my third point, that says that the contrary submission potentially disempowers applicants if the failure must be established at the date of the hearing, then it potentially can encourage tactical manoeuvres, and it puts into question the rationale for backdating to the date of the application.
Sorry, you'll have to...
Well, if the ground has to be established at the date of the hearing, then if the respondent has not maintained until shortly before the hearing, the ground won't be made out.
Sorry, say again?
If the ground has to be established at the date of the hearing, and in the 3 months before the hearing, the respondent is now maintaining, then if the ground has to be maintained at that date, then the application has to be dismissed, even if there's been a history of years of non-payment.
Sorry, has failed.
One would, yes.
Has failed.
At the date of the hearing. So
No,
one's looking at a
failed.
particular time.
Has failed is looking backwards.
Well, then, my lord, the word
Whether
has
it's
is
the
being
date of the
used.
application or the date of the hearing, it's has failed. So the words can apply equally to the date of the hearing or the date of the application.
So forgive me, my lord. Sorry. That construction suggests that any mispayment at any stage prior to the date of the hearing justifies the making of an order. And I say that can't be right.
Surely it can be intermittent, depending on what period one is looking at. There may be periods where reasonable maintenance was paid. There may be periods where it wasn't.
My lord, it's not clear to me.
If, which I don't think is apt, but if we are making this similar to a cause of action, it's a continuing cause of action. When you have a continuing nuisance, sometimes it's nuisance, sometimes it isn't. It's all for the judge at the hearing to reach a conclusion about.
Well, my lord, what I say is this. This is a piece of legislation that allows the court to interfere with a subsisting marriage. It is analogous to the court interfering with freedom of testamentary disposition under the Inheritance Act. There has to be a threshold that's met before the court wades in, as it were, into a subsisting marriage. And unless there is some threshold that says if there's more than just something that's been a failure in the past.
That's not the point. The threshold is has failed. And what I and Lord Justice Coulson are questioning is your submission that it disempowers applicants, because if at the date of the hearing or in the week before the hearing, the respondent starts paying what the court might otherwise assess as being reasonable maintenance, your submission was the claim would have to be dismissed. That's what we're addressing. And that's what we're questioning.
So, forgive me, I think what's being now suggested is that the word has failed means has at any time prior to the date of the hearing.
Well, if the application is issued in 2020 and it's heard a year later, for 9 months of that year, a respondent was paying nothing when they should have been paying £1,000. For the last 3 months of that year, the respondent pays £3,000, £1,000 a month. Are you saying the court would then have no power to make an order for maintenance back to the date of the application of £1,000 a month for the first 9 months?
My Lord, on the assumption that there's no material change in the party's financial circumstances during that time, then I would not argue against that, although it's my submission that the relevant period would be the 12 months prior to the date of the application, of course. Mr. Justice Mostyn deals with this in my submission
then
properly in his judgment.
That means your submission that it disempowers applicants because the application can be subverted by a respondent starting to pay seems unsustainable.
My Lord, let's take a slightly less stark example. As soon as the application to maintain is made, the respondent starts paying. If over the course of that 12-month period, 11 months he's been paying, does that mean that the application has to be dismissed at that point? I say, if you're doing that analysis, you're encouraging tactical behaviour on the part of the respondent. Whereas it's very clear, someone can say, unless you start maintaining, I'm going to make a Section 27 application. If they don't, the ground is made out of the date of the application. And what was done afterwards doesn't go to the court's jurisdiction. So, my Lord, I will come, if I may, to the last part of these submissions on the construction of Section 27, which is the argument that Section 27.3, which requires the court to consider the Section 25 factors in both assessing whether there's been a failure to maintain and what order to make. Of course, that is very similar to the way in which the court's decision-making process is set out in the Inheritance Act, and where there is a two-stage process. Was the provision made by the will and or intestacy such as to make reasonable financial provision for the applicant, and if not, what order should be made? Of course, the difference between Section 27 and the Inheritance Act is Section 3.5 of the Inheritance Act. My Lords, that is at tab B of the authorities bundle. Page 41. And of course there are some similarities here. Section 3.1 is broadly analogous to the Section 25 factors. And that checklist is directed to be considered by the court in both determining whether there was reasonable financial provision at all, and if so, what order to make. The difference is, my Lord, on page 42, the following page, Section 3, subsection 5, where the court is expressly directed to have take into account facts as known to the court of date hearing in determining matters under that section. And so what I say is that whereas a defective application under Section 27, where the ground is not made out at the date of the application, that cannot be made good by subsequent failure to maintain, that a change of circumstances between the death of the testator or the beginning of the application and the date of the hearing in an Inheritance Act case can make good what would otherwise be a a bad claim on the Inheritance Act. So that's the first point I make about section 27.3, is that if it had been intended to change the temporal scope of making the ground, one, I say, would have expected something similar to section 3.5 in section 27. The second thing I say about
Is
section...
there such a provision elsewhere in the Matrimonial Causes Act?
My lord, I don't believe there is, no.
And financial claims, as a matter of generality, are determined on the facts as at the date of the hearing.
My lord, yes, because there's no ground that needs to be established before one makes them. All you need is a decree nisi, or indeed, under section 22 for maintenance pending seed, all you need is a issued divorce petition. That's your gateway to the making of the order.
So all other financial provision claims, or for orders for financial provision, are determined as at the date of the hearing.
My lord, yes.
And this is an outlier.
My lord, yes, because it's the only application for financial provision which requires there to be proof of an objective state of facts before the court can make an order. It's an outlier in other respects, my lord, of course. It's an outlier in that it allows maintenance orders to be made without any connection to any other matrimonial proceedings. All the other financial orders, well, all the other orders that are being made in the first instance require there to be a decree nisi of nullity or divorce, or a decree of judicial separation. So, my lord, if the basis upon which the court is minded to consider that whatever West and West might have said, now with section 27.3 directing attention to section 25 factors, then West is no longer good law. I say that section 27.3 needs to be looked at in its own context. It doesn't, in my submission, change the temporal aspect of West. And the reason I say that is one has to simply look about where it has come from and why it comes about. And so, my lords, in all the legislation prior to the 1978 version of section 27, there's no requirement to have regard to any checklist at all. There's no checklist factors in the 1950 Act. There's none in the 1965 Act, and...
Well, you told us it was introduced by the 1978 amendments.
My lords, yes. So, if I can take you to the newest batch of authorities, the one which was paginated and passed up to your lordships this morning.
Just before you leave I referred Mr. Cayford yesterday to the procedure set out in the Family Procedures Rules to be adopted in respect of an application under section 27. And if the application is for maintenance and a lump sum, then the procedure is identical to the procedure which applies in all other applications for financial provision, including in respect to Form E's and everything else and first appointment. So that the rules treat both or all the applications as the same from a procedural point of view.
Well, Lord, yes. So
do you see that has any relevance?
None at all, my lord. The rules require, in this case, they required, as it happened in those days, they required a finding of Form E1 for various reasons, but it's not dissimilar to a Form E. It requires the last 12 months of the bank statements, and if the application is issued in January, one would expect to have an order requiring Form E's by, say, the end of February, so you've got 12 months bank statements 10 of which are going to be before the date of the application, so one's got the historical focus there. Of course, it's perfectly possible, as Mrs. Villiers did, to ask questions about financial circumstances before the 12 months preceding the date of the Form E, and Mr. Villiers answered those. So the fact that the procedure is the same, I say, makes no difference.
Well, in any event, presumably you would submit that you can't possibly construe an Act of 1973 amended in 1978 by reference to procedural rules introduced decades later.
My Lord, yes, the current ancillary relief procedure was introduced, I think, in the late 90s and was probably only extended to Section 27 proceedings by the FPR 2010 that came into force in 2011. And prior to that, I think there would have been just simply old-fashioned exchange of statements. So, my Lord, I've dealt with the Inheritance Act contrast. I've said that where Section 27.3 comes from, I was going to, I've already mentioned some aspects of Law Commission 77 and that being the Law Commission report that gave rise to the 1978 Act, which put the 1973 version of Section 27 in its current form. I was going to take the court from page 21 of the, forgive me, page 7 of the new clip handed up today. That, my Lord, is an extract, in fact, from Law Commission 25. And it's right to say that the Law Commission back in 1969 recognised some problems with what was then the 1965 Act, and the changes that are made between the old law and what we now have are done in a piecemeal fashion. You can see in paragraph 21 on page 7 of that clip the emphasis on... Sorry.
Where? Sorry.
So, my Lord, the clip...
You were on page 27.
I'm so sorry, my Lord. It's page 7. I'm sorry.
Page 7. Sorry, I misheard you.
And it's today's clip.
Yes. Sorry, I was just on the wrong page.
No, it's
yes.
my fault. I think I said page 27. So, my Lord, just to say that's the context. This is Lawcom 25 back in 1969, identifying the problems and saying that effectively we're going to have to sort out the law of failure to maintain in both the Magistrates' Court and the High Court at the same time. You can see here that the problems with willful neglect and the footnotes there refer to Jones and Jones, and indeed West and West, which is how I came across it. And that's effectively the genesis for all of these changes that are made in 1978. And, my Lords, we've already seen today, in the passage I took you to already, from Lawcom 77, that report was based on the assumption that the failure to maintain must exist at the date of the application, otherwise there'd be no reason for the desertion ground in Section 1 of the 1978 Act. So, my Lords, if I can ask you just briefly to look at the clip from Lawcom 77 yesterday. What you have at the end of that clip on page 117 internally.
Sorry, which one are we looking at?
I'm so sorry, my Lord. It's yesterday's Law Commission 77 clip, it's part 9 of that report dealing with amendments to the Matrimonial Causes Act.
This is we had some extracts from section 9 and then you've provided the whole of section.
My lord, yes.
And you've gone to the last page of that?
And my
page
lord, I'm grateful,
117.
yes.
Yep.
Yep.
No, I haven't found it yet. What's the starting page?
The starting page is 112, my lord.
Yes, I've got that. Yes, found it.
I'm so grateful, my lord. The big point here is that this is the culmination of the rationalisation exercise. Same substantive law to be applied in both the magistrates and High Court, except of course that the magistrates have got the 2 additional grounds for failure to maintain. But otherwise, that's that. I'm looking in particular at subparagraph D, my lords, on page 117. The amended section 27, in determining whether and if so how to exercise its powers under this section in favour of a spouse, the court should be required to have regard all the second case and the section 25 factors. That's the cross-reference. So that's how it's expressed in that recommendation. Whether and if so how to exercise its powers. And my lords, if one can put that clip down and pass now, if you give me to today's clip.
Yes.
One can see at page 40 40. This
Yes.
is an extract from the 1978 Act, implemented or enacted as a result of the Law Commission's report, how the amendments to section 27 are effected. And so one can see, for instance, in section 63(1), we have the full version of gender equality there. Section 63(2) inserts the current section 27 subsection 3. And one can see that it is the version more or less as we have now. It says inciting both whether there's been a failure to maintain and what order, if any, to make under this section, the court shall have regard to the circumstances of the case. And so, my lord, I just say that that is a slightly different way of wording from the recommendation that we've just been looking at in 9.24d.
You drew our attention to what was said in the Law Commission's report number 25, that desertion needed to be retained because otherwise there might be difficulty, otherwise the applicant would have to wait until... Is there any desertion is removed?
My lord, no. So, forgive me, that's Law Com 77, paragraph 211. And
What is it?
And that says... We've got this whole long list of things that could base, at the moment, under the 1960 Act. We're going to whittle those down to behaviour, desertion, and failure to maintain.
Yes.
And we're keeping desertion because
Exactly.
we don't want to have to later make her wait until he stops paying.
Yes. Desertion has gone.
No, it's still there, my lord.
Desertion in section 27.
Oh, forgive me. So the point I was making about section 27 is that so in the High Court, the only basis for making an order has always been failure to maintain. So you've got two systems.
Okay.
Because if you're going to the High Court and you're alleging desertion, you might as well get a divorce. That's the idea. The magistrates' courts are local for people who can't afford to go to the High Court and County Court. That's the feeling, and they may not be able to want to get a divorce, but they need a remedy now, and they need a remedy now even if he's deserted her and he hasn't yet stopped paying. So forgive me, my lord, in the High Court since
I see.
1949.
I thought you were drawing an analogy. You were saying Section 27. I understand. Thank you.
But what the analogy is that across the board, in all the legislation to do with failure to maintain, the grounds have always used the past tense, with the exception of it is for the time being an habitual drunkard or drug addict. So where there's been that, it's always been, I say, the focus on establishing your ground at the date of the application. The point I'm making here is this. The 1978 Act is the culmination of a process which leads to full gender equality, removal of the word willful, preventing adultery as an absolute bar, and ensuring consistency of approach in quantification between the High Court and the Magistrates' Court's provision. And the recommendation is, in deciding whether and if so how to exercise its powers, you have regard to Section 25 factors. That, in the Act, as we've just seen, gets extended to in deciding whether there's been a failure to maintain, and if so, what order, if any, to make.
Can you just enlighten me? What's the provision that enables an order to be made in the Magistrates' Court on the ground of desertion?
So, my lord, I can take you to it very quickly. It's Section 1 of the Domestic Proceedings and Magistrates' Courts Act 1978. In the today's bundle, it's at page 37 onwards. And so, effectively, you've got A, B, C, and D. Ignoring failure to maintain a child, you've got failing to maintain the applicant has behaved in such a way applicant is not reasonably expected to live with the respondent. That's the same wording as what is commonly and wrongly currently called unreasonable behaviour for divorce petitions, and then desertion.
So C and D are the two additional grounds you refer to?
My lord, yes. And they're broadly analogous to the non-adultery fault-based facts in the current divorce legislation. The difference is there's no requirement for any period of desertion, which you have to get in order to get a divorce. You have to show desertion for 2 years.
And what the Law Commission was saying is that a spouse who had been deserted or couldn't be reasonably expected to live with the respondent should be entitled to apply for a financial provision order based on the fact of desertion or unreasonable behaviour, and shouldn't have to wait
My lord, yes.
for either provision A or B to apply.
My lord, yes.
So it's put that way around rather than the other way around.
My lord, yes. So the reason why, for instance, Section 1D is there, because the Law Commission say she shouldn't have to wait until he stops paying if she's been deserted. So, my lord, my lords, the matter that I'm just about to bring to your attention is in Section 3, because Section 3.1 is a provision that's broadly analogous to Section 27.3 of the Matrimonial Causes Act. This was the novelty in the Magistrates' Court's jurisdiction, having to have regard to a checklist of factors modelled on Section 25. And the opening words of Section 3.1
Sorry, what page are you on?
This is page 38 of today's clip, my lord.
38, thank you.
And that simply says, where an application is made for an order under Section 2 on the basis of failure to maintain or behaviour or desertion, the court, in deciding whether to exercise its powers, and if so, in what manner, shall have regard to the Section 25 factors. There's some slight amendment to them, but they're more or less the same. And that is based on the same set of recommendations that led to 27.3. So the final piece of this jigsaw, my lords be pleased to note, is the fact that the Law Commission were saying the approach should be taken by the court in making orders under Section 2 of the 78 Act, or Section 27 of the 1973 Act, 1 in the Magistrates' Courts, 1 in the higher courts, should be the same. They should have regard to the same set of factors. The court today will notice that there's no requirement in Section 3(1) to have regard to those factors in determining whether there's been a failure to maintain in either Section 1A or B. And so, where Law Commission 78 is expressly saying same statutory guidelines to exercise this power in both the High Court under Section 27 and Magistrates' Court under Section 1 of the new Act, where that report expressly says you've got to have failure to maintain at the date of the application, I say the introduction of Section 27(3) as the basis for saying, well, now you've got to determine whether there's been a failure to maintain at the date of trial, doesn't stack up. You can't discern that intention from Parliament or the Law Commission.
I don't. Section 3(1) is different, as you pointed out, and it says the court has regard to those factors solely for the purpose of deciding whether to exercise its powers.
My Lord, yes.
Whereas Section 27(3) says the court has to have regard to all those factors both in determining whether the ground is established and in determining what order to make.
My Lord,
So
yes.
it's a different provision.
I say that, but I say the recommendation that gave rise to them is exactly the same. And
It's
that's
a
the
different-
recommendation I took the court
Yes,
to
but
at
is it-
9.24.
But it's a different provision.
My Lord, yes.
So why do you say it's different? Why are they not the same?
Well, I say it's an accident of drafting. I can't see any basis in the Law Commission report that says historically, and we're going to carry on making legislation for the magistrates' courts on the basis that you must have your ground established to take the application. But from now on in the High Court, we're going to change the law on that. Because that's effectively, without Section 27(3), my Lord, there's no basis to say West is wrong. There's no basis to say that the reasoning in West is no longer acted. So if Section 27(3) is the reason to say it's changed, I say you can't discern that intention from the Law Commission report. A Law Commission report that is still saying you need to have failure to maintain the date of the application, otherwise there'd be no need to have desertion as a ground.
It doesn't actually say that. It says, as I pointed out, that there's no. They thought there should be was no justification in making a wife who had been deserted to wait for a failure to maintain to arise, because she might be entitled to. She should be entitled to make an application for an order under Section 2, based on the fact of desertion or unreasonable behaviour.
My Lord, I'm sorry, there's maybe a distinction there that I'm not grasping. And I say that if the debate is about do we need desertion in the new section we're about to recommend, and the answer is yes, we do, because otherwise a person who is being maintained and who might not be being maintained, she shouldn't have to wait. So I say, my Lord, that there's no distinction between the way I express it and the way your Lordships express it. I mean, I may be missing something, but that's how I make my submission in relation to that point. I mean, the sentence, we do not think a deserted wife for whom her husband is providing reasonable maintenance should be required to wait until that maintenance has ceased before making her application.
Sorry, can we just go back to Section 3?
Of course not.
Because it seems to me that you need to see exactly what that's saying. Section 3 says, where an application is made for an order under Section 2, and that, when we look at Section 2, that takes us back to Section 1. The court, in deciding whether to exercise its powers under subsection 1A or B of that section, and if so, in what manner, shall have regard to the following matters. So there's a two-stage process there. 1, whether to exercise. 2, if so, in what manner. So when we then look at subsection 3 of section 27, which is substituted by section 63, at pages 40 and 41, that says when there's an application on the ground mentioned in 1A, then in deciding whether it's failed to provide and what order, if any, to make, again, it's a two-stage process. Stage 1, has there been a failure to provide reasonable process, and what order, if any, to make. So do I understand your submission, therefore, to be that although the wording is different, both provisions are contemplating a two-stage process?
My Lord, I say that in fact, section 27.3 is a three-stage process, although it's expressed in two. The first is the court has to have whether the ground's made out. The second thing is it going to make any order at all? And the thirdly, if the answer to that is yes, what order to make? So the words what order, if any, are doing the same, I say, as whether and if so, how. So I say that section 3.1 is analogous to section 27.3b. And I say if it wasn't for section 27.3a, have regard to section 25 factors in deciding whether the respondent has failed to provide means of maintenance, this argument that says that you've got to look at a date of trial could not simply be advanced. And I'm saying that it's simply a matter of drafting that it's in the Matrimonial Causes Act and not in the DPMCA. Because the recommendations that gave rise to both these provisions are the same. And there's no chink of light that says we need to make it more complicated or have more factors to be considered in the High Court and the Magistrates Court. And my Lord, if there's any room for doubt about that, if I can ask the court to turn to the short extract from yesterday, which is the entirety of Part 9 of the Law Com 77, pages 112 to 117. Paragraph 9.11 of that report at internal page 115 is very clear. Same statutory guidelines to apply in both sets of proceedings in both sets of courts. So just to sum up on that, I say West is binding, that section 27.3 cannot bear the weight that's placed on it, that says, well, you've got to have regard to section 25, that's here and now, therefore you've got to suddenly change the temporal scope of when the ground is made out, because that provision comes from a report that is expressly saying that you must have the ground made out at the date of the application, and the precise wording of section 27.3a is, I say, an accident of drafting if the same principles are to be applied in both the Magistrates and the High Court. My Lords, I'll turn on to ground 3, or the duration point, if I may. And before I come on to some legal submissions in relation to that, I would ask the court to bear in mind some key facts which are crucial to the exercise of discretion by the judge in this case. The first of those is that Mrs. Villiers issued a divorce petition in England and Wales in July of 2013. The second is that Mr. Villiers issued his Scottish divorce writ in the Dumbarton Sheriff Court in October 2014. And shortly afterwards, under the provisions I'm going to take the court to in a moment, the district judge stayed the English proceedings under the rules that required such a stay. And I'll come on to those provisions in just a moment. In terms of where the Scottish divorce proceedings have been, it's important to note two things. The Scots don't have decree nisi and decree absolute. There's one decree of divorce. And secondly, you cannot get your divorce in Scotland and then sort the finances out. The finances, the order is made to take effect on the decree. And so until the finances are sorted out, you don't get your decree. And my client would say that for the vast majority of time since 2014, his Scottish divorce proceedings have been sisted, or stayed in the English language, legal language, on account of the fact that there are these proceedings in this court. It is right to say that what I described as the bigamy bombshell in October 2020 also led to a stay, but that bomb has been successfully detonated or removed, and it is not the current cause of the cyst in Scotland. It is, my client's understanding, it's the English financial proceedings that are again saying that the cyst must continue.
So
because
there's
until
a disagreement between you as to why the Scottish particular proceedings assisted, and we don't have any. This wasn't addressed by the judge.
No.
So what
Well,
can we do?
I'm just saying that whatever happened in October 2020 has been and gone. That obstacle in the road has been cleared. They remain sisted for the same reason they were sisted beforehand, because of the financial difficulties.
Well, I appreciate your. It's the same way as Mr. Caford's submission. It's a submission of. You're both giving us evidence.
My Lord, I understand. My Lord, if I can take the court to the provision in the Domicile and Matrimonial Proceedings Act, it's the authorities bundle. No, it's not going to work. Sorry. Tab C, thank you. The page 45 of that sets out the beginning of Schedule 1 to that 1973 Act. One can see in paragraph 3 of that schedule definition section. So another jurisdiction is any jurisdiction outside England and Wales. Related jurisdiction is effectively another jurisdiction within the British Isles, obviously including Scotland. And the obligatory stay provision is at page 46. This provision resulted from a joint Law Commission report from the Scottish and English Law Commissions back in 1973, and there is analogous provision, I think, in Schedule 2 of this Act that applies in Scotland, to have effectively, if the parties live together after the marriage and their last matrimonial home was in one of those related jurisdictions, and it doesn't matter when the divorce proceedings took place, who was first in time, you are getting divorced in the jurisdiction in which that last matrimonial home was in. That's the oversimplified summary of that provision. And I also ask the court to bear in mind that, as it were, those provisions, as say, apply regardless of who's first in time. Obviously, my client's Scottish divorce writ was second in time. I just bring to the court's attention the current Maneuverings in Scotland. If one looks at the supplemental bundle on page B398.
I'm sure it's my fault. I thought the question of duration was about the duration of orders made under Section 27.
My Lord, yes. I'm coming on to the provision of paragraph 11 of this schedule, which is a key provision which the judge refers to as to why this order, in this case, should not exceed a decree in Scotland. So, my Lord, that's the reason why I'm taking you to this provision.
Sorry, what provision?
So, the provision we're looking at in Schedule 1 to the 1973 Act. Just for your Lordship's information, you'll see at page B398 is a plea entered by Mrs. Villiers in the Scottish proceedings in October 2020. And you'll see from paragraph 2A that she is disputing the fact that Mr. Villiers lived within the territory of the Sheriffdom of Dumbarton for 40 days prior to the raising of the action. So there's still potentially a jurisdiction dispute in Scotland. All I would say about that is that even if my client hadn't met that jurisdictional provision, such that his petition in Scotland were dismissed, he could issue a fresh one, and that would always take precedence over any English divorce petition, because it's not a first-in-time argument. And so here we have a jurisdictional challenge that one can only hazard a guess as to why it's been made, but it's not going to deprive the Scottish Court of divorce jurisdiction. So, my Lords, if I can take you back to the authorities bundle, and I was looking at, so this is the provision, paragraph 8 of Schedule 1 of the 1973 Act, that led to the obligatory stay of the English proceedings. What the paragraph 11 of that schedule does is say what happens to any financial orders or the power to make financial orders in those stayed English proceedings. And effectively, on page 47 or 48 in subparagraph 2, the rule is you cannot get any financial orders made within those stay English proceedings. There is, one sees in subparagraph B there, a provision that says any existing periodical payments order will expire after 3 months. That's sufficient, it was seen by the draft of legislation, to get oneself before the Scottish court or the other court in the other part of the British Isles. And one could also see there is an exception in subparagraph 2C that you could say, even if my divorce petition has been stayed because there's a Scottish divorce writ that takes precedence under paragraph 8, I am in urgent need of some funds, and so I'd like an order to go beyond that 3-month period, or indeed have a fresh order made. And it's noteworthy that Mrs. Villiers did not seek to invoke the court's jurisdiction under those provisions. She consented to the dismissal of her English divorce petition.
What do you say the relevance is of paragraph 11, which is dealing with applications under stayed or in respect of stayed divorce proceedings in section 27,
well, my Lord,
referred to in paragraph 11?
So it's in Mr. Justice Mostyn's judgment, forgive me, I think it's paragraph 45. Paragraph 46, subparagraph 3 on page 100 of the core bundle. I say that the submission I made to Mr. Justice Mostyn, which he agreed with, is still entirely right, that where Mrs. Villiers' English divorce petition has been dismissed, where Parliament makes provision as to how long any maintenance order would last within those proceedings, it is highly anomalous for that order, an order in Section 27, to last beyond the duration of an order made that could have been made in those state divorce proceedings.
The anomalous.
My Lord, yes.
The duration of an order under Section 27 can specifically, by statutory provision, extend beyond the date of a divorce.
My Lord, yes.
Divorce anywhere. So how is that provision impacted by paragraph 11 of the Domicile and Matrimonial Proceedings Act?
My Lord, Parliament's made express provision for the duration of a maintenance order where someone in the position of Mrs. Villiers has brought a divorce action and had it dismissed or stayed. And then she seeks to circumvent that by bringing a Section 27 application.
Why is it circumventing? It's a different statutory provision which Parliament has expressly provided, if an order is made, it can extend beyond a divorce. So why is it circumventing? Why is using one statutory provision within its terms circumventing another statutory provision within its terms?
My Lord, the court has always had a discretion as to how long to make a maintenance order in every single case. And the mere fact that it can exist beyond a divorce does not mean that on the facts of a particular case, where divorce proceedings that could have taken place in this country have been dismissed, and there is the right to seek maintenance in the Scottish proceedings, I say it is circumvention to exercise those rights of Section 27, because Section 27, one can only apply during the subsistence of the marriage. One needs to be married at the date of the final order as well. Lord, let me just, if I may, develop this point. Let's assume that Mrs. Villiers was aware of this provision and said to Judge Aitken, don't dismiss my petition, you've stayed it, but I need money from the English court. I'm not going to bring Section 27, I'm going to invoke the jurisdiction in paragraph 11(2)(c), and I say that it's appropriate for you to make an order. How long would that order have lasted? And my lords, the answer to that is it would not have lasted beyond decree of divorce in Scotland. If it was a maintenance pending suit order...
Yes, but that's because it's a different statutory provision. And you would have to address what Lord Sales said when this case went to the Supreme Court about, the passages that Mr. Cafer took us to yesterday about the wife's entitlement and about how forum convenience doesn't apply.
My lord, forgive me, that's a circular argument. It says because there is a right under English law to apply, it should always be allowed to be exercised, regardless of the existence of any foreign divorce proceedings. It's a matter of English law as to how long an order made under Section 27 can last. And I say that this was a discretionary factor, and the most compelling item in that discretion was the fact that the English divorce proceedings had been stayed and then dismissed, and any order that she might conceivably have obtained in the English divorce proceedings would have come to an end either 3 months after the end of that order, or after the stay of the English proceedings, or on dismissal of the English proceedings, or at the very latest, on the decree of divorce in Scotland. And where there are remedies in a jurisdiction which is, if we're not going to be chauvinist about it, another part in the United Kingdom, say it's an entirely proper exercise of discretion in those circumstances.
So you support the judge's analysis that there would have to be exceptional circumstances to justify the continuation of an order, a periodical payments order under Section 27, beyond the date of a foreign divorce?
My lord, yes. My lord, Mr. Justice Mostyn talks in grand language, if I may say so, about exorbitant jurisdiction. But I mean, the simple point is this.
Exorbitant extraterrestrial jurisdiction.
Forgive me.
I say I don't think I've ever exercised. I've always stayed on this planet.
My lord, I'm not seeking to defend the language, but what's behind the language is a really simple core truth that since 1984, if you want to get from an English court periodical payments that will take effect after a foreign divorce, you have a statutory remedy to do so. It's in Part 3 of the 1984 Act. Part 3 of the 1984 Act says, where you have been divorced overseas, you can apply, if you satisfy jurisdictional requirements, for permission to apply for financial provision, even though you've been divorced overseas, even though you might have been able to get some money in those proceedings. Of course, one of the factors that the court here will take into account is what rights the applicant had under the law of that foreign divorce, whether he or she availed themselves of those rights, and if they didn't, why not? But the simple fact is there is a statutory provision that says if you want maintenance to take effect after a foreign divorce, there is a statutory provision for doing so. And the key aspect of this case, which is different, is that you cannot do that in relation to a Scottish divorce. So when we say, colloquially, there's no Part 3 after a Scottish divorce, we say that the Parliament, both as a matter of English law and a matter of Scottish law, probably as a matter of Northern Irish law as well, has said, if you get divorced in one part of the United Kingdom, you will not be able to apply for financial provision after that divorce in another part of the United Kingdom. So if you can't get post-divorce maintenance after a foreign divorce, after a Scottish divorce, Mr. Justice Mostyn's grand language is encapsulating the view, why should you be able to get it before a foreign divorce that will take effect after a foreign divorce? Well, that's a simple point. That's why I say it's circumvention. Parliament has directed that there is a specific remedy for post-divorce periodical payments. It said you can't get that following a Scottish divorce. If you can't get it following a Scottish divorce, you should not, in my submission, be able to get it prior to a Scottish divorce. That's the second limb, I say, of why the judge's discretion was absolutely right on the facts of this case. Now, my Lord, one of the planks, and there were many in my submission, one of the planks on which the court founded, Mr. Justice Mostyn founded his view about discretion, was the fact that Section 27 was originally designed to facilitate the performance of the common law duty by a husband to maintain his wife. And for your Lordship's reference, I included the judge's request for submissions about that point, and I included submissions that we made about that. It was not a point that, on behalf of Mr. Villiers, we said had any great weight. There were arguments both for and against whether the common law duty had any continuing relevance to that. What I would say is that there are the two submissions I make about that. Firstly, that McFarlane does not assist my own friend because all of the passages that he took the court to yesterday were obligatory. The decision in McFarlane was whether, use a colloquialism, a wife married to a high earner but with a short career span could obtain an order for periodical payments beyond her current needs so that she could stockpile for when her husband stopped working. And Mr. Lord Justice Thorpe's route to making the order that he did was expressly based on the need for the court to consider a clean break. All of the passages that Learned Friend took you were obiter. But be that as it may, I say it really doesn't matter whether the common law duty applies or not. There are a very many great number of factors that are relevant. And here I say that the modern statutory framework is very different to Bragg in the 1920s and Wood in the 1950s. And the single most important aspect of that is the discovery, invention, as it were, of the clean break in the 1970s, which was something that would have not been within the contemplation of the Court of Appeal in the 1950s or earlier. So, my Lords, my submission on the law in terms of discretion, I'll make effectively 6 points as to what the modern statutory framework says. The first is this: all periodical payments orders made on divorce are subject to the court's duty under section 25A of the Matrimonial Causes Act. And for your lordship's reference, that is at page forgive me, I'm sorry. Page 27, thank you very much. Page 27 of the authorities bundle in, I think it's tab A. That casts a mandatory duty on the court in making that order at the time of the divorce to consider whether it would be appropriate to use the colloquial term to impose either an immediate clean break, i.e. no periodical payments at all, or a deferred periodical break, i.e. periodical payments for such term as would appear just. That duty does not, in contrast, apply to any of the order under section 27. So section 27 order can last until further order. It can last during the joint lives of the party. Regardless of what it says, if it survives the divorce, it's got to end on remarriage. That's all that section 28.2 says. Section 28.2 is making sure that if the payee remarries, it doesn't continue. It assumes that the order has survived on divorce, and of course that's the question that this discretion goes to. It doesn't help the court decide how to exercise that discretion at all. So that duty in section 25A is the duty that applies to consider a clean break at the time of making the order. Under section 31 of the Matrimonial Causes Act, that duty, which I don't think we have in the bundle, I'm sorry my lord, that duty applies on application to vary a periodical payments order. So someone has a periodical payments order made on the time of the divorce. 5 years later, they're entitled to say, it's time for a clean break. And on that application, the court has the power, whether by consent or otherwise, to say, I'm going to end the maintenance order, but I'm going to order a further lump sum, I'm going to order a pension sharing order, I'm going to make a property adjustment order. So capitalisation of future maintenance is an express power when the court is bringing a maintenance order made after divorce to an end, either immediately or in the near future. Again, those capitalisation powers do not apply to a Section 27 maintenance order. And there's a reason for that. Why would there be a duty to consider a clean break in Section 27 when the order is made during the subsistence of a marriage which may never come to an end? So the fact that it can go on indefinitely doesn't mean that where the court knows there's going to be a divorce, it can't seek to either impose a term or say, you're going to get divorced somewhere and the clean break can be considered in those proceedings. And so this will hold the ring until the clean break can be considered in those proceedings. Although the third point about this is that, as the judge says in his judgment, and this is at page 96 of the core bundle, paragraph 37, he's said quite rightly in my submission that the decision in Bragg and Bragg that a magistrate's court's maintenance order survives.
Which paragraph?
So forgive me, my lord, it's page 96, paragraph 37. And the context is that he has cited Bragg and Bragg. Bragg and Bragg says a magistrate's court's maintenance order under the 1895 Act did not automatically come to an end with a subsequent divorce. Now, that was justified on the basis of convenience, and one can see halfway down page 96, 4 lines up from the end of that citation, you can see the magistrate thought that was a very convenient thing, that this order should subsist, and the court, which is close at hand to the parties, should be able to give the wife assistance if she needed it. And of course, that's from a different world where there were local magistrates' courts, and the High Court or the Family Court were more remote or less accessible to those without the means to pay. And of course, the practice of family law has completely changed. And indeed, although we still have the Domestic Proceedings and Magistrates Courts Act, the courts with family jurisdiction these days are the Family Court and the High Court. And any person in a domestic divorce against whom an order is made under Section 27 is never going to say, fine, let it carry on after the divorce. The absolute thing they won't do is say, yeah, that's fine. And the reason why they won't do it is because they're never going to get their clean break. So what they will do is they will say, fine, if you must have a maintenance order against me, make an order on Section 23, and then at least I can at least apply at some point for a clean break before I die, which is not available to them if an order continues under Section 27. So,
sorry, I don't understand that. The statutory provision isn't there, but the court could still decide that it was appropriate to effect a clean break by ordering a lump sum.
I'd order it, forgive me, it can't do that. It certainly can't order the full capitalisation power is not available to it. And there's no duty on the court to consider a clean break.
Yeah, but you said the court couldn't. The court can. The court can bring the maintenance to an end, either with or without a lump sum.
Why would anybody in those circumstances have an order where it's on a variation the court must consider a clean break, as opposed to an order where the court might consider it a clean break?
Your submission was the court couldn't.
My Lord, forgive me, I misspoke, I'm sorry. But my submission would be that no one in their right mind would submit to the continuation of a domestic order under Section 27 because there is no express duty on the court to consider a clean break in those cases, and the capitalisation powers are not available. So the idea that in a domestic case a Section 27 order is going to continue is fanciful in my submission. And that, therefore, as I say, equally relevant to its continuation in a non-domestic case, an international case.
Mr. Horton, I'm sure it's my fault. I want to try and put all of these submissions into the context of this case.
My Lord, yes.
In the judgment, the judge turns to this case at paragraph 54, and he sets out the facts, and he does so on the basis that the wife has to satisfy what he calls the condition precedent. He then comes to the condition precedent of paragraph 127, and he says that she hasn't met it. And he has his fallback position that if he's wrong about that, then there's the £10,000 per year. I think, obviously, we have your submissions on the question of the condition precedent and the has failed point, and you're either right or wrong about that. If there is, under Section 27, in this case, an entitlement to be paid something, then the question I think you're now dealing with is the question of how long that lasts. Is that right? That's what's meant by duration. And that's a matter of discretion.
My Lord, yes.
It's not apparent to me from the judgment that the judge ever exercised any discretion on that question.
Paragraph 143, my Lord. Page 143 at page 127.
Yes. I think that rather makes the point. In accordance with the principles I've formulated above, that's 1 to 53. That's his
Well, in particular,
exegesis,
paragraph
right or
46,
wrong.
my Lord.
Yes, but
Discretion.
that's his legal analysis. And as you say, ending at 47 with it being exorbitant extraterritorial exercise of jurisdiction. In other words, what I can't see is something that says, well, that is along the lines of the submissions you're now making. As a matter of discretion, you wouldn't do it beyond a particular point.
Well, he does use the word discretion in that very paragraph, to be fair. Immediately after the quote, second line, it is to exercise the discretion exactly in the way that.
Yeah.
It is to exercise the substantive
I'm interested in
discretion.
his exercise of the discretion.
Well, my lord,
Anyway, to the extent that we have it, it's 143 referring back to the principles
45
I
and
formulated.
45 and 46 and 47.
Well, it's all of it.
Well, my lord, the
It's
discretion.
quite difficult to. It's quite difficult to divide up.
My lord, the passage which deals with his conclusions on.
So sorry to
45
interrupt you,
on.
just so as we've got the point. You referred to some other paragraphs, and as I understand it, what you're saying is we start at 45, where he says, in my judgment, these developments, blah, 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 should lead to the discretion normally being exercised in the following manner. And then in 46, he refers to a normal exercise of the discretion in this way twice, before setting out 1, 2, and 3. And then he refers again to discretion in 47. So, as I understand it, your submission is that those paragraphs set out the judge's view as to how the discretion, as it is expressly put about 6 or 7 times, is to be exercised in a normal case.
My lord, yes.
And then your submission is that that is what he is applying at 143. Do I have you correct?
My lord, yes. And I think it would be harsh indeed to criticise a trial judge who set out at some length how he would normally exercise discretion and then refers back to that and says, I'm going to exercise it the normal way, for him to be criticised, saying, not expressly saying, I have decided that there are no exceptional reasons for me not to do it in the normal way.
Yes,
I think that would be reading
he
the
limits
judgment
the
to-
scope of his discretion by saying there have to be exceptional circumstances when you have a foreign divorce in what he calls a friendly state, which is an expression I must admit I'm not sure I see how that's applicable in circumstances of a family breakdown, or in another part of the British Islands. That's what. So he says, because of these factors, it's only in exceptional circumstances that you would exercise your discretion by making a maintenance order to last beyond a Scottish divorce or a divorce in a friendly state.
Oh, yeah.
As I say, whatever that is. Can you help me with what a friendly state is?
Forgive me, I
In this
can't
context?
quite see the reference to friendly state, my lord.
It's paragraph 45, subparagraph 1.
My lord, I'm surmising here that he is talking about jurisdiction, which is one where there is financial provision available in that jurisdiction on divorce, and where it's perfectly possible for that person to make an application.
I don't think the expression a friendly state features in Part 3 of the 1984 Act.
My lord, yes. Forgive me, my lord. It may be
Anyway,
an
that's
odd
like,
choice of phrase. I respectfully suggest it has no bearing on the effect
it's-
of this case, because we are dealing with a case in another part of the British Islands.
I just wondered whether
I
that
don't-
came from anybody who have any idea what it meant.
I don't recall it
No,
being referred
okay,
to in
thank
submissions, my lord.
But so what the judge says in paragraph at the bottom of paragraph 47, it would amount to an exorbitant extraterritorial exercise of jurisdiction to allow a maintenance order to have effect after a foreign divorce, save in exceptional circumstances. And you support that formulation of the test that he applied when exercising his discretion.
My lord, yes. And I say that that comes from the factor in particular that's set out in subparagraph 3 on the top of that page, in paragraph 46, subparagraph 3. It's the point that he's made in a slightly different way that I've made it today, that you have, ordinarily you've got the right, if there's an overseas divorce, for an applicant to bring a case here under Part 3 to claim financial provision following that foreign divorce. You don't have that following a divorce in Scotland, and therefore he says it can be safely assumed that there is a right to apply for post-divorce maintenance in that jurisdiction dealing with divorce, and it will be fairly adjudged. So that's the point I've made already, my lord. You can't get post-divorce maintenance after the foreign divorce. You shouldn't be able to get it before the foreign divorce, or the Scottish divorce in this case.
Well, except Section 27 allows you to get maintenance before a foreign divorce, wherever it takes place, and gives the court power to make an order beyond the divorce, wherever it takes place.
I would, yes.
It doesn't, it's not Part 3, it's a separate provision that gives a party the right to apply during the course of the marriage for an order that will subsist beyond the end of the marriage.
My lord, yes. And I say that there are two things that have happened since 1978 in its final form, changed with 1973 Act. One is we have a clean break, it wasn't in contemplation at that time, and two, we have the 1984 Act. Both of those factors have got to cut down the otherwise open-ended discretion.
But so you would say that if you can apply under Part 3, sorry, if you could apply under Part 3 but don't, and apply under Section 27, that the court should exercise its power, except you have to make it before. But so you're saying if you haven't applied under Section 27, sorry, if you have applied under Section 27, you then get divorced other than in Scotland, the court should do what?
Well, my lord, even applying wood and wood before the clean break was invented and before the 84 Act came along, the approach to the case was, if you had the right to make an application in the foreign court and it wasn't difficult for you to get there, i.e. Scotland, not Las Vegas, you should be left to your rights of that foreign court. Wood and wood is the exception. Wood and wood is the case where she's divorced without her knowledge in Las Vegas.
Yes, foreign convenience doesn't apply. We know that in respect of this application.
My lord, forgive me, I'm not making a foreign non-convenience point. I'm simply saying that even before the clean break came along and the 84 Act came along, the approach to the exercise of discretion to discharge an order made under the magistrate's jurisdiction was that in most cases where there was the opportunity for the party to make an application for maintenance in a foreign jurisdiction, they'd be left to their rights in that foreign jurisdiction. That's wood and wood is the outlier in those cases because she'd been divorced against her will by someone who was not deserving of the court's attention. She'd been divorced without her notice. She what was called an ex parte divorce. She found out about it afterwards, and the court said it had to recognise those proceedings. So I say wood and wood is an outlier, but even if you accept that that it's possible, it's still got to take account of the fact that we have a clean break now, and that we have the 84 Act, and the approach to a court is going to be your maintenance, your protestant compensatoire in France is going to be determined by what the French court thinks of as your ongoing NATO maintenance. Why is an English court going to make a maintenance order that might have effect following a French divorce when there's a right to claim capitalised maintenance in France?
So your submission is really to the effect that when the court is making an order under Section 27, it should only continue until a divorce, wherever that divorce takes place.
Well, Lord, yes, and exactly as Mr. Justice Mostyn says in paragraph 45. Now, it might be different if there was a pending divorce or a threat of divorce in perhaps, say, I don't know, an Arab jurisdiction where there was no right to claim financial provision or something of that like, where that might be said to be an unfriendly state in terms of unfriendly to applicants for financial provisions, we say, and where there might be a need, therefore, for an order to be made prior to the court being seized of a Part 3 application afterwards. So there was no gap between provision now and making the application on Part 3. But, my lord, I say this, the modern statutory framework with the introduction of the clean break and the 84 Act really means that there is, I say, very limited role for the court making an order that has effect after divorce, which was always seen to be anomalous and only justified on the basis of convenience, people being able to continue to go to their local magistrates' court, and or by the fact that, I mean, I'd say the last point I want to make on this is that what comes out of the early authorities is that an innocent English wife should not be deprived of her maintenance because someone's managed to divorce her overseas. So if she was at fault in the divorce, she'd been found guilty of a matrimonial offence, either in this country or overseas, her maintenance would come to an end. But Mrs. Wood, for example, was not guilty of any matrimonial offence. She had done nothing wrong, and the assumption was, well, she should still have her maintenance post-divorce. You don't need to do that anymore. You've got Part 3 of the 84 Act. That's the rescue mechanism for people in those situations.
You've slightly gone off the Part 3 submission, and you referred to accepted practice in respect of authorities that I don't think we have in the bundle.
My Lord, no. I mean, Wood and Wood is in the judgment. I reread it for today, but I didn't think it was that important. It's my main submission that whatever Wood says, it's overtaken by the fact that we have a clean break and we have the 84 Act, that you don't need to continue an English Section 27 order or Magistrates' Courts order beyond a foreign divorce to ensure that a blameless English wife continues to be provided for after her marriage, after a divorce, because she can make a Part 3 application. And Part 3 is, it seems to me, under the 84 Act, it is going to do all of the heavy lifting that's required by the otherwise anomalous continuation of an order that would continue after the date of divorce. And with respect, that's what the judge is saying in paragraph 43 when he talks about convenience. That it was going to be very inconvenient for Mrs. Wood to have to go to Nevada and seek to assert her rights there in proceedings where she'd never been served notice of in getting divorced. Whereas it's not inconvenient for someone, Mrs. Kirk, to litigate her financial issues in Edinburgh.
That sounds getting close to forum non-convenience. You're using the word convenient.
Well, that's the word in the authorities, and that's the word that was relevant to the jurisdiction to discharge a magistrate's court's maintenance order after the Act itself, or the Section 7 of the Act, is at page 98, paragraph 40 of the paragraph 40 of the judgment. But certainly the Court of Appeal felt that the convenience of someone being able to assert their rights in a foreign jurisdiction was relevant to the exercise of that discretion. Now,
Mr. Horton, can you help me? Because there's something about this whole aspect of the case which I find very hard to follow. So, as I understand it, it's common ground that on the face of the statute, see in particular section 28 subsection 2, the court has a power to make an order that would continue beyond divorce. And as we saw yesterday, on the face of the statute, there is no discrimination on the face of the statute between divorces in England and Wales and divorces in other jurisdictions. So on the face of the statute, one has that power in either scenario. I could understand an argument that says, yes, there's a power to make a divorce, an order extending beyond divorce, but in a normal case, you would never exercise it because there is superior machinery that can be invoked in the circumstances of a divorce. And then you would say, and it's no different if it's a foreign divorce. But your starting point for the exercise of the discretion would be to consider the position with regard to an English divorce and say, well, there's no difference on the face of the statute, whether it's English or foreign, we exercise the discretion in the same way. Now, that approach I can understand and see how it can be reconciled with the statutory language. But unless I've misread the judgment, that's not really the way the judge approaches it. He seems to start from the assumption that a foreign divorce is inherently different. Now, what's the justification for that, having regard to the statutory language?
My Lord, I don't know. I would surmise this, that we know that Section 37 is very rare. On most marital breakdowns, the full divorce or nullity or judicial separation machinery is invoked, and the wide range of powers that are invoked in their circumstances. And an applicant, well, so there are possibly two circumstances in which you would choose Section 37 over a divorce. One is that you haven't got jurisdiction for divorce, slightly different jurisdictional grounds for Section 37 to divorce or judicial separation. The second is you're trying to wriggle out of a prenup, is what happened in H&H. And the decision that we looked at yesterday on Section 37 there, the finding was that although there was a prenup and neither party would make any claims arising out of the breakdown of the marriage, the judge found that a Section 37 claim was not such a claim and was not prevented by a prenup. And I suspect we're all going to amend our prenup precedents as a result, but the intention, I would imagine, behind the makers of that was that any kind of application would have been forestalled by the prenuptial agreement. But those are the two circumstances you do it. So I suppose, my Lord, answering your question, anyone invoking Section 27 in this country, assuming they had jurisdiction to invoke a divorce at some time, let's say it's within the first year of marriage, you can't petition for divorce in the first year of time, would ordinarily do so, and then their maintenance order in the divorce would take over what they had got until then. And as I say, the applicant will get a wider range of powers available to her by making an application for financial remedies in the divorce proceedings, and a respondent is likely to want to have an order that's subject to the court's duty under Section 25A and Section 31 to have a variation possible and a
all right, that's an interesting tour d'horizon. Yeah. But do I understand what you've just said in this way? That the difference is this, that if we suppose that in the case of purely English proceedings with no foreign element, an order is made under Section 27, which, let us say for the sake of argument, is expressed to continue for joint lives, and therefore on its face post-divorce, that in the event of English divorce and an ancillary relief order being made at that stage, the first order will automatically come to an end. Is that your submission? No,
it wouldn't automatically come to an end, but the overwhelming likelihood is that someone would apply for it to be either overtaken by a Section 23 periodical payments order or replaced by something else. My Lord, the practice of family law has...
All right, but if it doesn't automatically come to an end, there would have to be a subsequent order of the court putting it to an end.
My Lord, yes.
And what power would the court be exercising in that scenario?
My Lord, it would probably be an application to discharge under Section 31 on the basis that there's going to be either a maintenance pending suit order to replace it or an interim periodical payments order made in the divorce proceedings. There are, as I understand it, statutory powers of variation in the Domestic Proceedings and Matrimonial Causes Act, Matrimonial Proceedings Act, but although nobody uses that procedure anymore, I mean, if there are a tiny number of Section 27 orders, there are infinitesimally small number of orders made under the 78 Act. And I suppose what the judge is talking about in the domestic situation is the passage of paragraph 37, my Lord, because it's almost sort of class-based divide that working classes would go to the magistrates' courts, and the middle classes and upper classes would go to the High Court. And the magistrates' courts provided a system of justice. And it's the only reason to have your magistrates' court's order continuing after divorce is for the convenience for them not to have to get an order from the High Court. And that's completely changed. I mean, there is one family court that deals with all matters, which is why that there are. I can remember going to the magistrates' courts dealing with enforcement applications at early stage of my career, but very few substantive orders actually made under the 78 Act. Almost all orders were made in divorce proceedings and registered there for enforcement. So, my lord, to be fair, I think he does deal with domestic first, but he says it's anomalous to have an order going ahead. Its justification was convenience, and that justification doesn't really apply anymore, because anyone who can get themselves to the family court to issue a Section 27 application can also get themselves to the family court and issue a judicial separation petition, which is possible to do within the first year of marriage, even if they can't yet get divorced.
But it isn't all of that. And aren't all of your answers really saying, assuming that there's a power to make the order, in this case under Section 27, why would you not make an order under Section 27 until further order of the court?
My lord, because this case is different. Ordinarily, if the parties went to the court and they say, we have no current plans to issue divorce proceedings, then the court will make that order until further order, because there's no matrimonial proceedings contemplated. But here we know not only that there are proceedings contemplated, that we are in a situation where they're ready to go in Scotland, subject to assist, and subject to the ability of the Scots court to deal with all matters of financial matters.
The order that I've indicated wouldn't stop the Scottish courts dealing with whatever they wanted to.
Well, potentially, my lord, in the sense that there is a interesting point, because this is an old pre-Brexit case, that it might be argued that an English order for maintenance precluded the Scottish court making any order for maintenance. There's an argument both ways. There's maintenance within marriage and maintenance after marriage, and whether they are the same cause of action or whether they're simply related causes of action. But it's possible that by making an English maintenance order, the court in Scotland couldn't do that. I mean, the Scottish approach is not generally to make maintenance orders, but to adjust capital in the light of a maintenance claim. And it would be in difficulty in dealing with that if there's an English maintenance order. But, my lord, the point is that where you have, as the judge says in his judgment, you know that there are divorce proceedings on foot, then you make an order that deals with the situation until that court can deal with post-divorce maintenance. That's the right thing to do. It's the sensible thing to do. Have one court deal with all aspects in one go. I mean, that meets the overriding objective. And as I say, that meets the overriding objective in both a domestic and a foreign case. And the foreign case here, in particular Scotland, I say that he was absolutely right in saying if you can't get post-divorce maintenance because there's no access to Part 3, that's a very powerful consideration in not making post-divorce maintenance before the divorce is pronounced. So, my lord, the final point I wanted to make about this duration point is, as I say, you don't need to continue an English order post a foreign divorce in order to protect the deserving applicant, because there will be justice done, either because there'll be financial provision made in another part of the United Kingdom, or there'll be access to the right to apply under Part 3 of the 1984 Act. And that's because we live, as I say, in that very different world. My lords, the last point I want to make on this, therefore, is that let's assume that the court had jurisdiction and it makes a maintenance order for £10,000 a year for joint lives. At what point does that order run out? Does Mr. Villiers have to apply every so often in this court to have it discharged against the background that, as my learned friend accepts, in the court with divorce jurisdiction, where there is a duty to consider a clean break, the maintenance order would only last for 3 years. I say that by limiting the order to the date of the Scottish divorce, the judge is allowing that court to consider what the right term and quantification of post-divorce maintenance in the obvious place where it can be done. And he's absolutely right in my submission to say that we shouldn't be chauvinist about foreign jurisdictions, including, especially in this case, Scotland. Well, those are my submissions in relation to duration point. But fundamentally, on the facts of this case, knowing that her maintenance could not have extended, even if there had been an order in the English divorce proceedings for 3 months, it is, in my submission, anonymous for that order to continue beyond that. And I say that his analysis of the relevant principles, whether or not underpinned by any vestige of the common law duty, are absolutely right. And a way of making Section 27, which is in itself an outlier, work in a modern statutory framework, which has, as I say, a clean break, which has the 84 Act. The alternative is, my lord, whether it's, and I say this not in relation to this case, because I accept there's no role for forum non-convenience in this case, but the alternative is potentially a large number of applications that can be made where someone satisfies a jurisdictional requirement, looking to get post-divorce maintenance from English courts, which are known to be generous, looking to have those made post-divorce. And if one encourages this kind of application by allowing it to extend beyond the divorce, one is encouraging a rash of forum non-convenient challenges now that it is possible to do so. Family courts, creaking and groaning as they are, do not need this extra work, in my submission. And that's another reason why Mr. Justice Mostyn's exercise discretion was entirely right.
But that presumably was akin to at least some of the arguments before the Supreme Court, which they didn't accept. If it's a matter of discretion, it will always, the duration point being a matter of discretion, that will always turn on the facts of the particular case.
Indeed, but forgive me, discretion was not before the Supreme Court.
No, discretion wasn't. That was the forum non-convenience. So your inter rorem point, oh well, the family courts are going to be flooded with Section 27 applications. We're stuck with that because that's what the Supreme Court
No, my lord, we're not. So forgive me, we're under a different, both within the EU and internationally and within the UK, we're in a different jurisdictional regime. So the effect of the Supreme Court decision was that under the then regulation which applied, as between the different parts of the UK,
Section 27 has been amended with effect from the 31st December 2020. We don't have the amended version before us because it's not relevant to the facts of the present case,
my lord,
but it is changed.
And those regulations which forbade forum non-convenience have gone, and everyone now accepts that, which is, it's my submission and we've made it, that if Mrs. Villiers were to make a fresh Section 27 application now, Mr. Villiers would be able to make a forum non-convenience challenge to that and say, let's get it all done in Scotland, as he's been saying throughout. And I say that if you interpret this way, and or you say Mr. Justice Mostyn was wrong about discretion, then you are encouraging people who want to bank jurisdiction in England, a maintenance creditor friendly state, to get post-divorce jurisdiction, and to have many people therefore coming along and either trying to run forum non-convenience argument and saying, well, they're getting divorced somewhere else, let's do it all in the same place, or to have continued arguments about the discretion on the facts of that case, how long it should run. And my judgment, my submission rather, the judgment of Mr. Justice Mostyn deals with those and prevents the court being flooded by those kind of applications. My lords,
before you leave that, paragraph 46 of the judgment, the judge imports what he describes as the influence of the common law rule, that the duty to maintain subsists. So that's one of the foundations for his exceptional circumstances conclusion. Do you support or not support that factor?
My Lord, I say it's irrelevant. They say the submissions we made to Mr. Justice Mostyn were that.
Sorry, when you say irrelevant, what do you mean by irrelevant?
I say that the common law duty one doesn't need the common law duty to reach the conclusion that he does.
So it was not a relevant factor for the judge to take into account?
My Lord, the way in which he phrased his analysis of the discretion was based on a number of factors, one of which was the common law duty. One doesn't need a common law duty to get to those factors. His conclusion is still correct, whether or not he is right about the common law duty.
I'm asking you for your submission as to whether you say it was an irrelevant factor or a relevant factor.
I say it was at best tangential, because he says...
So that means potentially relevant, is it?
Potentially relevant, my Lord, but as I say, right. the main factors in my submission are the developments that he talks about in paragraph 45.
So if it was potentially relevant, your submission is that he was right to take it into account?
My Lord, let me say this. I don't seek to defend the common law duty aspect of the judgment. What I say is that his discretion would have been exercised, and the principles that he formulated for exercise discretion would have been exactly the same, regardless of the presence or absence of that common law duty. And there are three elements to the way in which he's done that, my Lord. There are, in paragraph 45...
It's all right. So I think you're submitting that the judge was wrong to take it into account.
My Lord, I'm not making that submission. I say that it doesn't matter either way.
Well, no, he took it into account. And what I'm trying to get from you is your submission as whether he was right or wrong to take it into account.
My Lord, I say this. If he took it into account, it made no material difference to the way in which he formulated those proposals. So,
I'm going to try once more. Do you submit he was right or to take it into account, or that he should not have taken it into account?
I make no submission on the point, my Lord. As I say, it doesn't make a difference.
It's not very helpful.
My Lord,
he was either right or not right to take into account.
Well, will you just give me a moment, please? My Lord, appeals are against decisions, not judgments, my Lord. And I don't think I can say anything more than what I've said already, that the formulation of those proposals and the way he exercised discretion, I say, were correct, certainly not wrong, and not one which this court should interfere with. There is an aspect of his decision which we made submissions to him, which say that the common law duty might or might not be relevant. And it was a matter for him. We didn't express a view in the court below. We didn't express a view. We don't express a view in this court either. What I do say is that the key aspects or the key foundations for that discretion are in the matters that I've referred to in this court today, and they're the matters set out in, say, in paragraphs 45 and 46. They weren't the only factors. He does have regard to the common law duty, and I say his decision is supportable and correct, whether he is right or wrong about that. And, my Lord, the reason why I haven't addressed you on that, save in passing, is I just think it's a massive red herring, and this court's got, as it were, more important things to do than decide how many angels were dancing on the head of that particular pin. My Lord, those are my submissions on the discretion and on the duration point. I'd like to just say this in closing. My Lord, there was a passage yesterday when there was reference to how could an applicant obtain an injunction to restrain disposal of assets where there was no current failure to maintain, but a threat to do so and a threat to dispose of assets. And it's my submission that, strictly speaking, there would be no cause of action under Section 27 at that stage, and that the court ought not properly, therefore, to, if it was requiring there to be a valid cause of action, so 27 application, not properly make an injunction. And I say that that's very interesting, but not the end of the world, because anyone in that position would be in a position to petition for judicial separation and bring an application for financial remedies in that application and bring an application for an injunction in those proceedings. So the absence of an injunction in Section 27 in those factors would not bar a remedy to someone who needed it in those factors of their case. And even if, taking this example to its possibly slightly absurd conclusion, that even if there was no jurisdiction to issue a judicial separation petition, a judge could make an English freezing order in support of a foreign matrimonial application. So the argument that we need to construe Section 27 and the ground at the time of the order based on the need for an injunction doesn't, I say, stack up. My Lord, secondly, I'd say this, that Section 27 is concerned with the state interfering in a way in a subsisting marriage. There are no potentially proceedings for divorce or judicial separation on foot. Marriage may never be dissolved, and therefore I say that there has to be a threshold met before the state intervenes, and the state has always expressed that threshold as being a state of affairs that existed at the date of the application. And my Lord, the third submission in closing is that this is a hard case. It's an unusual case where there is such a delay between issue and hearing. It makes not a jot of difference in your average case. It made not a jot of difference, for instance, in the two authorities my learned friend referred this court to. In both of those cases, there was no material difference between the level of provision and the level of need at the date of the application and the date of the hearing. And so, my Lord, I say one doesn't need to make bad law because of this hard case. And my Lord, finally, in terms of jurisdiction, the court will know my submission is that West and West is finding that the amendments to the 73 Act by the 1978 Act do not undermine that, because the 78 Act followed a Law Commission report which was expressly predicated on the basis that the ground must be in existence at the date of the application. Lord, those are my submissions.
Can I just ask you about this question? Mr. Caford made clear at the beginning of his submissions, as set out in the notice, that what order he's seeking. In other words, he's not seeking a case being remitted, which I thought was one possible order he might be seeking. And in effect, if we decide that the judge exercised his discretion wrongly, he's asking us to make such order under Section 27 as we consider is fair or just. So he's asking us, as I say, in the event that we decide the judge exercised his discretion wrongly, to re-exercise that discretion.
Well, my Lord, I didn't understand him to be making that submission. I understood him to be saying he limited his maintenance claim to £10,000 a year. The notice of appeal says at least £10,000 a year, but I understood him to be saying that he didn't challenge the assessment of what was reasonable on the current circumstances.
No, I understand. The judge didn't make that order. The judge indicated what he might have done or would have done if he had decided otherwise on what he regarded as sort of essentially jurisdiction points. So he's asking us to find or conclude the judge exercised his discretion wrongly in dismissing the claim. And he's asking us to make an order under Section 27. In making that order, we would have to decide what order was fair, just, whatever word you want to use, under Section 27.
My lord, yes. Forgive me, my lord. I didn't understand my learned friend either A, to depart from what to say. I understood the chronology to be he was asking for at least £10,000 in notice of appeal. In oral submissions, he said £10,000 a year. There's no challenge to the findings of fact at any stage. The only challenge is to the jurisdiction point.
Sorry.
So
the judge did not exercise his discretion by making an order. He dismissed the claim. What Mr. Cayford is seeking is not a rehearing, but for us to exercise the discretion on the basis that the judge was wrong to dismiss the claim.
And my lord, I'd understood
so we
him.
are exercising the Section 27 powers.
My lord, I'd understood him to say that he was seeking an order for £10,000 a year.
Yes,
if there's anything else that's being sought,
we are making.
before I sit down.
We are making that. We would be making that order.
My lord, yes.
We would be making that order under Section 27, and thereby exercising the discretionary power given by Section 27. That's the analysis I, as obviously speaking solely for myself, I have applied to the submissions made by Mr. Cayford.
I have to say I understood it differently, because as I understood it, the judge dismissed the application for failure to comply with what he called the condition precedent. In other words, he said no jurisdiction.
No ground made out.
But in paragraph 140 and following, he expressly exercised his discretion on the footing that he was wrong to do so. And I understood that where we ended up in the light of Mr. Cayford's submissions was that if he was right on jurisdiction, so the judge was wrong to dismiss the application, he accepted the exercise of discretion, in paragraph 140 as to the amount, £10,000. And where he said the judge went wrong in the exercise of his discretion was solely as to duration. And then there was the question mark about the lump sum adjourned application.
My lord, I agree with all that, and I don't. I'm sorry if I'm appearing to not get the point, but in circumstances where there's no challenge to that conditional or contingent evaluation, Mr. Linifred hasn't said that is wrong. He hasn't addressed this cause in saying that's wrong. The only proper way for this court to exercise its discretion afresh would be to make an order that the judge indicated that he would have made had he had jurisdiction.
Right. So your submission is the only way for this court to exercise its discretion is to adopt the £10,000.
My lord, yes. I'm not.
And the duration? No, because that's being challenged.
My lord, I say he was right about the duration. I mean, they're different points.
No, it's all right. I'm looking at it because I am, of course, addressing the application to adjourn the lump sum. And I haven't fully understand whether that is to sustain the jurisdiction or what the underlying reason is for that. But if you're saying the only way for us to exercise our jurisdiction is by making an order for £10,000, subject to the issue of duration, then I need your assistance on why you say it's not open for us to exercise our jurisdiction by adjourning the lump sum application.
Well, because there is simply no ground of appeal that says he was wrong to do so. He was never asked to do that. And there's no ground of appeal attacking his decision about that. Because, and I suppose, my lord, I'd better address you on the cases that deal with adjourning lump sums. And there's two things, isn't there? There's the nature of relief under Section 25, Section 27, and then there's the general Section 25 cases on adjourning lump sums. But, I mean, failure to maintain.
In the footnote.
Sorry, these are the footnote points, my lord. Yes, and my learned friend didn't develop them. I've got some things to say about them if necessary. But I'd understood that because it wasn't dealt with in the grounds, it wasn't open to my learned friend to make these points. But if the Lord thinks otherwise, I will address them. So the first thing, and I think this is dealt with, forgive me, in our skeleton. I'll never find it, excuse me, sorry. Right at the outset.
Can I just ask you a question before we embark on this? Do you make any submission as to the difference jurisdictionally in no order being made for a lump sum or for a lump sum and the lump sum application being adjourned?
Yes, absolutely.
Use what? You say that if it's not adjourned, there would be no power for the court later to order a lump sum. Is that what you're saying?
No. I think my submission is this, my lord. If the application for a lump sum is adjourned, then these proceedings continue in force. These proceedings continue in force. There's no power for them to be stayed on formal non-convenience grounds. There's no power. And indeed, the Scottish court will have to decide what on earth it's going to do when it's got a claim for £1 million plus interest against an adjourned lump sum claim in this jurisdiction. I mean, there would be a danger of related actions, even on...
Yes, let's not go down that road.
So that's the complications that it gives rise to. If the application for a lump sum is dismissed, it doesn't stop a further application for under Section 27 being made, but to sort of bank jurisdiction, I mean, you have to be married on the date of the application.
I was just asking you for a submission on the difference between either silence in respect of the lump sum application or the lump sum application, the lump sum application being adjourned specifically. That's what I'm asking your assistance on.
Okay. So, my lord, the difference is this: is that the proceedings would have come to an end. There would be a maintenance order in force that would be capable of being varied. And if no lump sum order was made, any application for a lump sum order would need to be the subject of a fresh application. If the lump sum is adjourned, then within the existing set of proceedings, an application could be made to restore that application.
Thank you. That's
and
right.
Case management directions could be given on that application to restore.
Thank you.
So, my lord, the fundamental difference between a Section 25 claim, which is made on divorce, is that the court is endeavouring to achieve a fair outcome having regard to all three of the strands of fairness. We've got needs, sharing, and compensation. Court's got a much wider range of powers. And in contrast, in my submission, the focus of a Section 27 application is there has been a failure to maintain, and the court ought to make an order for reasonable maintenance. It needs to correct or remedy that neglect, to use the old language. If there are no current resources available to meet a lump sum, it will mean that there is no failure to make reasonable lump sum provision, and the application must therefore be dismissed. So they're fundamentally different beasts, Section 27 and Section 25. And the mere fact that one gets the ground established does not mean the court has got the same focus as it would do in a Section 25 case. My lords, the second aspect of those aspects is that even in a proper financial remedy on divorce case, as I said yesterday in passing, the approach is that adjourning a lump sum claim is exceptional and should only be contemplated where there is likely to be some resource available to meet that in the near future. And and it's been expressed a number of different ways in different cases. So, my lord, if one looks at page 24 of the bundle, footnote 4 of Moylan and Friends skeleton, I don't have citations for any of those or notes on any of those particular cases, but my submission is that there needs to be something, as I say, in the near future, not just the foreseeable future, that would justify the adjournment of the claim.
Thank you.
And what's the something? I think you said yesterday, did you say imminent was the word?
I used the word near future, my lord. That's the phrase I think used in a decision of Mr. Justice Mumby.
Okay, so something, some what, likely change, definite change? How's the...
My lord, rather than me paraphrasing, someone let me see if I can just find something quickly, forgive me.
Because, I mean, we can find these ourselves. It's just getting some idea of what sort of territory.
I say one of the most helpful review of the authorities, it would be Mr. Justice Mumby, and it's a case called C&C. It's reported at 2010, volume 1 of the Family Law Reports, at 337. And reading from head note number 3 of that report, when asked to adjourn a lump sum claim, the head note writer says this: an adjournment should be directed only if the property in question was likely to become available, quotes, in the near future, or, quotes, within the next few years. And case law suggested that 4 to 5 years was the longest period for which an adjournment should be granted. And if one applies that dicta or holding the facts of this case, the evidence simply doesn't warrant any adjournment. The findings about the availability of resources from both sets of trustees are not a real possibility in the foreseeable future. And Mr. Justice Mumby in that case contrasted the foreseeable future, which he said might be 15 years, to the near future. As you've seen, he's already said that's for 4 or 5 years. That's the authority I would rely on. There are other cases, obviously, including the ones my own friends have cited, but that one reviews most of the earlier cases. So.
Peter, any other questions? No. No, thank you very much. Yes, Mr. Cayford.
Lord,
How long do you think you're going to be?
well, it may depend on how much lordships want to hear from me about the various matters that's been raised.
5 to 1. Do you want to start, or do you want to stop now and start at 5 to 2? I don't mind. Should we stop now and start again at 5 to 2?
If it's going to be more than
5. Oh, that's a bit long.
15.
I don't know whether you heard that.
I did.
We're debating whether or not to hear you. How long do you think you might be?
Well,
More than 15 minutes?
I'd love to be less than 15 minutes, but I don't anticipate it's likely.
Right. Then I think we'll stop now and start again at 5 to 2.
Very well.
Thank you for that frankness.